Is the US government trying to expand the pool of people who can be denaturalized? A new bill has been introduced in both the Senate and the House called the Fraud Accountability Act, and it's getting attention because it would dramatically expand the reach of denaturalization, especially by tying it to fraud convictions, including fraud that happens after someone has already become a US citizen. In this video, I'm going to explain what the bill is proposing, how it would expand denaturalization, who it could apply to, and a few practical thoughts about what this could mean in the real world. I'm also going to share why, even though the language sounds alarming, it's important to keep this in perspective, because a bill being introduced is not the same thing as a bill becoming law. If you've watched any of my other videos on denaturalization, you already know I've covered the full denaturalization process in detail. I'm not going to retouch everything from scratch here. This is an update video because I know many of you have reached out about this bill, and I know some of you are already feeling anxious. The goal today is clarity, what the bill actually says and what I think about it. Welcome back to the channel. My name is Adrian Pandai. I'm an attorney who helps foreign nationals navigate the US legal system. Before I started my own law firm, I worked at the Department of Justice, including work connected to denaturalization cases. So I'm going to do my best to break this down in a way that's accurate, practical, and easy to follow. And if you find this content helpful, subscribe and like the video so you'll get updates when I post new immigration law and policy videos. Now, let's get into it. The Fraud Accountability Act was introduced in both the House and the Senate, and it appears to be a response to a recent daycare fraud scandal. While the bill is framed around fraud accountability and punishment, a large portion of it focuses on immigration consequences, especially consequences for permanent residents and for naturalized US citizens. Here is the biggest change and the part that has people most concerned. Under this bill, a naturalized US citizen could be denaturalized for fraud committed after they became a US citizen. That is not how denaturalization generally works today. Under current law and practice, denaturalization is usually tied to the way citizenship was obtained in the first place. In other words, denaturalization typically focuses on whether the person illegally procured citizenship, meaning they were not actually eligible, or whether they committed fraud or made a material misrepresentation during the naturalization process itself. The classic situation is there was a lie, concealment, or disqualifying fact during the path to citizenship that would have changed the outcome if the government had known the truth. Crimes committed after naturalization are normally handled through the criminal justice system. A US citizen who commits a crime can be prosecuted, convicted, and punished in criminal court. But denaturalization is not usually treated as an extra penalty for criminal conduct that happened after someone became a citizen. This bill would shift that concept in a major way. It would turn denaturalization into something that can function like a punishment tied to a later fraud conviction, even when the fraud did not occur during the naturalization process. So, how does the bill try to accomplish that? One of the most significant mechanisms is that it effectively removes the separate civil court denaturalization process and connects denaturalization to the criminal case itself. Under the proposal, if someone is convicted of fraud in criminal court, that same court would then be required to move directly into denaturalization. That's a huge departure from the way many denaturalization cases are handled now, which are typically brought as civil actions. Civil denaturalization cases involve separate procedures, separate standards, litigation over evidence, and a judge making a determination after a civil process. Under this bill's approach, the criminal conviction becomes the trigger and denaturalization becomes part of what happens next. And here is another part that frankly makes the proposal even more intense. The bill is written in mandatory language. It doesn't say the judge may denaturalize. It uses language like the judge shall denaturalize. In other words, if the conviction exists and the statute applies, denaturalization is not discretionary. There is no room for leniency built into the way it's drafted. The bill also lowers the threshold for what qualifies as fraud for these purposes. Right now, in many immigration contexts, a fraud offense becomes an aggravated felony only if the loss to the victim exceeds $10,000. That dollar figure matters in the current legal framework, but under this bill, the $10,000 threshold is removed. The bill refers broadly to fraud against private individuals, funds, corporations, or the government without keeping that monetary floor. What would that mean in practice for lawful permanent residents? It could expand deportability. Under current law, not every fraud conviction triggers the most severe immigration consequences. But if the bill removes the threshold and treats fraud broadly, then permanent residents could face removal for a wider range of fraud convictions, even ones involving smaller dollar amounts. And for naturalized citizens, the bill would potentially go even further. If a naturalized citizen is convicted of fraud, the bill's language would require the criminal judge to denaturalize them as part of that process. The bill does this by expanding or changing definitions in Section 237A(2) of the Immigration and Nationality Act, which is the part of the law that deals with deportability and deportable offenses. From a legal structure standpoint, this is one reason the bill is so striking. Deportability concepts are traditionally aimed at non-citizens, people in lawful permanent resident status, people in temporary statuses, or people with no status. U.S. citizens are not deportable, but this bill attempts to pull those deportability-based concepts into a denaturalization framework, meaning in effect, it uses immigration removal logic as a tool against certain U.S. citizens, specifically naturalized U.S. citizens. And finally, the bill includes a retroactivity provision. It would apply retroactively to September 30th, 1996. That's almost 30 years back. So, under the proposal, someone with a qualifying fraud conviction dating back to that period could potentially face consequences today, removal if they're a permanent resident, or denaturalization if they're a naturalized citizen. Now, before I give you my thoughts, I want to make one point very clearly because it's the most important practical point in this entire conversation. Congress introduces a lot of bills. Most bills do not become law. A bill being introduced does not mean it will pass. It does not mean it will survive the committee process. It does not mean it will pass both chambers. It does not mean it will be signed by the president, and it definitely does not mean it is law today. Bills like this often appear in reaction to high-profile scandals because lawmakers want to show constituents they are responding and taking action. That political reality leads to proposals that can be very aggressive on paper. But aggressive proposals frequently face major obstacles long before they become enforceable law. Now, let's talk about legal concerns with the bill as written. There are at least two major Supreme Court precedent issues that immediately come to mind. First is Afroyim versus Rusk, a Supreme Court case that stands for the principle that Congress cannot strip a person of U.S. citizenship without the person's voluntary renunciation. That case is often cited as a major constitutional protection of citizenship status. If a bill creates a mechanism where citizenship is taken away as a mandatory consequence of a later criminal conviction, especially for conduct that occurred after naturalization, you can expect serious constitutional challenges based on Afroyim and related doctrine. Second, the bill raises concerns about creating two classes of citizens, natural-born citizens and naturalized citizens. Natural-born citizens cannot be denaturalized because they were never naturalized. Their citizenship is fundamentally different in origin. Under this proposal, naturalized citizens would face a unique and additional penalty, loss of citizenship for certain post-naturalization convictions, while natural-born citizens would not face that specific consequence for the same conduct. That kind of unequal treatment has been challenged before, and Schneider versus Rusk is one of the key cases people discuss in this area. The broader principle is that once a person is a citizen, they generally enjoy the same constitutional protections and rights as other citizens, and the government cannot lightly create second-class citizenship for naturalized citizens. So I think the bill as drafted would face serious legal attacks. Between Afroyim and equal protection concepts reflected in cases like Schneider, there are major questions about whether this framework could survive judicial review. On top of the constitutional and precedent issues, there are also practical concerns. The bill's definition and scope of fraud is extremely broad. Removing the $10,000 threshold changes the nature of how the law impacts people. It raises the possibility that relatively minor conduct, still criminal, still wrong, but not necessarily on the same level as massive fraud, could lead to the most severe consequence possible for a naturalized citizen, losing citizenship entirely. And stepping back, I do find the broader trend concerning. Denaturalization and deportation are not the same thing. deportation is a tool aimed at non-citizens. Denaturalization historically has been focused on whether citizenship was improperly obtained. When denaturalization starts being discussed as a punishment for conduct after someone becomes a citizen, it shifts the concept toward treating naturalized citizens as more permanently conditional than other citizens. That's a significant change in how citizenship is understood in the US legal system. That said, I want to end where I started. I'm not convinced this bill will become law, and even if it did, I would expect immediate litigation and strong constitutional challenges. There are very serious legal problems with what the bill is trying to do, and the courts would have a lot to say about it. If you have questions or you want me to cover a specific part of the bill in more detail, like the retroactivity section, the fraud definition, or how this could interact with existing denaturalization law, leave a comment below. I read the comments and I'll do my best to make follow-up videos if there's enough interest.